Insurance companies do not always deny disability claims. Yes, sometimes they do outright just deny a claim. But often what they do is steer a claim away from being a total disability claim into a residual disability claim because it costs them less money. Total disability means they're paying the full amount. Residual disability, or what we also call partial disability, it's cheaper because the insurance company is paying only a percentage of the monthly benefit. The insurance companies sometimes argue that someone is residually disabled if they're still able to work on a part-time basis, or if they're able to perform some duties of their occupation. And so they argue they're not totally disabled. And by arguing for residual disability, the insurance company then gets to claim that they want more documents, records, and information they otherwise would not be able to get if it was a total disability case. For example, like tax returns and other financial documentation. But it's not always true that someone is not totally disabled merely because they're continuing to work in some way or performing some duties of their occupation. As an example, an ophthalmologist who cannot perform eye surgery is no longer an ophthalmologist but an optometrist. That person is totally disabled. A liver transplant surgeon, for example, a case we won in federal court in Illinois, who cannot perform liver transplants but can perform general liver surgeries, is totally disabled. And it doesn't matter if their income went through the roof, because the question for total disability is whether you cannot perform the substantial and material duties of your occupation such that you can be said no longer to be performing in that occupation, and whether you've lost income or made more money as a result of this occupational change matters not to that inquiry. Look, disability insurance claims are complex. They need strategy. They need expertise. But that is what we bring to the table as experts in this field.